Okay, just give a few minutes till everyone gets in.
Can anybody hear me?
Can we hear you?
Yes.
We hear you.
Yes, we do.
Did anybody else have trouble getting into the meeting?
No.
Not yet.
No.
Everybody in, Christie?
It appears everyone is in.
Can I check to see if my people are in?
Sure.
Dr. and Mrs. Kotler, are you in the meeting?
We're here.
Okay.
Okay.
Ms. Coffin, Allison Coffin, are you in the meeting?
Yes, I'm here.
And Mr. Murphy, Larry Murphy? Larry?
There's no Larry Murphy up.
Here he's coming in now.
Okay. Mr. Trevino? Larry, are you in?
He might be connecting to audio. Give him a second.
I'm sorry for my impatience.
No, that's okay.
Well, we have a few things to do first, so why don't we get going on that and then we can check
You
in.
open the meeting, Christie? Stand for the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
At this time, I would just ask that everybody remain muted until it is your turn to speak. If we have too much background noise, we can't hear the people who are providing the testimony. The Open Public Meetings Act, the 48-hour notice as required under the Open Public Meetings Act has been met, as notice of this meeting was emailed on August 3rd and published in the Asbury Park Press, the Co-Star, and the Coaster. A copy has been placed on the bulletin board in the Borough office, and a copy has been filed with the Borough Clerk. Mr. Affuso.
Here.
Mr. Quinlan and Mr. Correa are excused this evening. Mr. Wade.
Here.
Mr. Mayor.
Here.
Ms. Phillips.
Here.
Ms. Rosenberg.
Here.
Mr. Critelli.
Here.
Ms. Brunel.
Here.
And Chair Rosenberg.
Here.
And also present this evening is Mark Kittrick, Attorney to the Board, Gerald Frieda, Board Engineer, and Christine Bell, our Board Planner.
Before we get started, I'd like to let the public know that the case of Irvington Manor, 217 McCabe Avenue will not be held tonight. And I'd like to make a motion that there will be notice of a meeting of October 15th for the Zoning Board of Adjustment for Bradley Beach, but they must renotice. That has been that long since the application started.
Second.
All in favor?
Aye.
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 Any nays? So anybody interested in that application, that will not be heard tonight, and we hope it'll be heard October 15th if they renotice. Approval of the minutes.
Make a motion for approval.
I make a motion that we approve the minutes of July 16, 2020.
I second it.
Mr. Wade's my second.
Yes.
Yes.
Mr. Critelli.
Yes.
Ms. Rosenberg.
Yes.
Mr. Affuso.
Yes.
Ms. Phillips.
Yes.
Mr. Wade.
Yes.
Mr. Mayor.
Yes.
And Chair Rosenberg.
Yes.
Okay.
I make a motion, we approve the resolution of 2020-12 for Daniel Walsh Park Place. Those eligible to vote can vote. Second?
Second. Second.
Mr. Mayor's my second.
Yes.
Mr. Critelli,
Yes.
Mr. Afuso,
Yes.
Ms. Phillips,
Yes.
Mr. Wade,
yes,
Mr. Mayor,
Yes.
and Chair Rosenberg.
Yes. I make a motion, Resolution 2020-13 for Greg McKay, Block 20, Lot 7603, Park Place. Those eligible to vote may vote. Second?
Second. I think. Doesn't matter.
Mr. Critelli,
Yes.
Mr. Afuso,
Yes.
Ms. Phillips,
Yes.
Mr. Wade,
yes,
Mr. Mayor,
Yes.
and Chair Rosenberg.
Yes.
Okay. Bill says mute. Mute my audio. So-
Next case?
The only application under consideration this evening, since we've carried the Irvington Manor case to October 15th, would be
I'm here. Okay.
ZB
Here.
ZB 2005, Beth and Harold Kotler, Block 78, Lot 14, 306 Monmouth Avenue. The applicant's proposing to demolish an existing garage and construct a two-story accessory garage, having a two-car garage on the first floor and a residential apartment above, requiring variances for the height of the detached garage, minimum side yard setback for accessory structure, living accommodations on both floors, and maximum impervious coverage. Applicants represented by Richard Stone.
Okay. Mute. It says mute here.
Whoever is Karen, we have to mute you because you're
Unmute.
talking over everyone. Okay, sorry, Mr. Stone.
Mr. Kittrick is on. I take it that the board, first let me enter my appearance again. Recall all of you that in the June meeting, I indicated to the board that I have the pleasure of representing the applicant Kotler in regard to this application. In the June meeting, there was some dialogue from an objector, Mr. Cohen. I must assume that Mr. Cohen is on this meeting as well. One of the things that disturbed me back then was that the objection that was raised with respect to the notice was a late call, when it's hopeful that just as an applicant is required to provide information timely, it would have been best if the objector or any objector provided the board, applicant's counsel, applicant's experts with any issues that he might have. In the June meeting, there was an issue raised with regard to the notice. Frankly, I believe that the notice was adequate, but in order to make sure that that issue was not raised at some later date, we agreed to adjourn the hearing for 2 months, giving an opportunity for my client to order a full-blown architect's plan, which we timely submitted, and that we crafted a far more detailed notice in order to adequately respond to the objector. I want to reinforce that at the time of the June meeting, it was then and it remains now that that original notice was satisfactory. But what I was hoping to avoid is that in the event that the application proceeded to its conclusion and without being presumptuous that it was approved, I didn't want there to be a procedural attack on the application. So I agreed to carry the hearing until this date. Either late last night or early this morning, Ms. Dickert was kind enough to forward over to my office a rather detailed communication from, in this case, Thomas T.J. Cohn, this time Bradley Beach public citizen. I see there was a modification to his last characterization, but it was a rather detailed list of objections that Mr. Cohen had. And of course, as always, an objector has a right to make those objections. But again, I point to the board's attention that the items contained in this myriad list were certainly well known to Mr. Cohen before this morning or late last night. And I just want to make sure that the record is clear that I object to the late notice to the board professionals, to the applicant, to the applicant's attorney, all of which could have been done before. I should point out to you.
That's the lawyer, Richard Stone.
I'm sorry, I didn't hear that.
That, it's somebody who keeps unmuting. Go ahead, Mr. Stone, I'm sorry.
So, I also want to make sure that the record is clear that earlier this week, and I don't remember if it was Monday or Tuesday, I received an unsolicited call at my law office from Mr. Cohen. I indicated to him then, and I assume that he would confirm now, that I inquired as to whether or not he was represented by an attorney. He told me then that he was not, but that he had engaged a planner. And again, I'm assuming that the planner is available tonight. I have not received, nor have any of us received, I don't think, any record or a report from his proposed planner. But he did go through some detail, Mr. Cohen did, about items that he objected to. And I would hope that I know Ms. Dickert must have, and again, I'm assuming, I hope without being presumptuous, that the information provided by Mr. Cohen was disseminated to all of the board members, and that we might have those in front of us now, including Mr. Kittrick, because I do have some questions about these things, because certainly before we can get this application underway,
Mute.
I believe
Right
that.
on that, and we'll mute.
Sorry, Mr. Stone.
Okay.
Excuse me one second. Who is that individual?
Whoever Karen is, I'm not sure. It just says Karen.
Okay, so they need to stay muted until they're going to speak. And if it keeps happening, we're going to have to take other measures. Okay? Don't want to do that, but we have to proceed. So,
You know, I haven't done, but you know, as a result of this new environment we're in, I've only done a few of these. But ordinarily, I guess if we were in
Fine,
the
but it's not.
if we were in the meeting
One more chance.
in person, just as we wouldn't permit or
Correct.
I would have anybody from speaking out of turn. I guess we're doing the same thing here. Am I correct, Mr. Kittrick?
that's correct. So let's keep rolling.
Okay, so if all of us have Mr. Cohen's communication dated Thursday, August 20th, 2020 at 9:50 a.m. Well, actually, that's not correct.
That was, yeah,
Yeah,
Mr.
right.
Stone, that was the prior objection. And actually the new objection, since I got it late last night, it was not distributed to the board members. It was only distributed to Mr. Kittrick, yourself, and it was posted on the website.
Do the board members have this this document now?
They do not.
No.
Do they have the ability to access it so that when we review it, they will be able to see what's on it?
I can put, can you hold on 1 second?
Yes.
I'll attempt to share my screen.
I'm sorry about that, Ms. Dickert.
Nope, that's okay.
I just assumed that
I was
because,
just scrambling around. You know, I don't work in Bradley Beach full time, so.
but I see here that Mr. Cohen sent it, it appears that to you,
At 10 to 8 last night.
right, 7:49 last night.
Yes.
So certainly you wouldn't have disseminated that last night. I don't suppose at 8 o'clock at night, the night before a meeting, you'd be on your computer working for
No,
Bradley Beach?
sorry, I was not.
Okay, so that none of us, Mr. Kittrick, nor myself received this until this morning, am I right?
Correct.
And even as late as tonight, at the outset of this meeting, not other than us discussing it now, none of the board members have seen it, am I right?
The board members have not seen it unless they have viewed it on the website.
Okay, so with that in mind, might I ask Mr. Cohen, since the board members didn't have an opportunity to see this,
Temporarily unmuted.
and I would defer, of course, to Mr. Kittrick, but it seems to me that this would fall under a general heading, housekeeping. And because if there are any procedural issues that have to be raised, I suspect I would respectfully
Temporarily unmuted, but we
suggest that these items and others should be discussed before the meeting gets started, before the application process gets started. And I would defer to Mr. Kittrick.
Yeah, I don't have any objection to that. So I think that, and both sides will have the opportunity to address this, so.
Okay, so what I would ask is Mr. Cohen now the ability to address these various issues and bring them up before the board? Is he attending the meeting?
Yes,
Mr.
I'm here. I'm
Yes.
here. I had my hand raised.
Yeah.
Thomas Cohen, 612 Third Avenue. I'd be
And-
happy to address all these issues. But first of all, I really would like to address this issue that Mr. Stone keeps bringing up about the timeliness. So in the Zoom document of the agenda tonight, I'm going to read you what it says. It says,
Before you start that, I just want to make it clear as the reason we're having this discussion now. At this point, this board has not accepted jurisdiction in this matter. So we're having this discussion before there's any ruling on that. Okay?
Yeah,
Yeah, I mean, we're not getting anywhere.
it plainly says in the town's document for this Zoom meeting, if you have information or exhibits you wish to be considered and entered into the record, you will have to email them to the board secretary, Christy Dicker, in advance of the meeting so they may be marked into evidence. There is no time frame, Mr. Kittrick, none. It's your own document created by the Borough of Bradley Beach. My documents should stand as they were submitted in plenty of time.
Okay, number one, before I'd like to, may I respond to that, Mr. Kittrick?
Of course.
Okay, so number one, the communication in and of itself, I would suggest, is not evidential. There are items contained in the document, clearly hearsay. Mr. Cohen has not been sworn in, and I would like him to be sworn in. And I don't have any objection to him bringing up each one of the four, I believe that there are 4 line items contained in this document, which may very well lead to a further discussion generally about the jurisdiction of the board. But I would like him to go through each one so that I can respond to it.
You'd like him to go through each one in relation to whatever argument he wants to put forth. Is that correct?
Yeah, yes, Mr.
All right. So moving forward, there's not a discussion about, the timeliness. Is that it?
No, I anticipate that at some point, the record of these proceedings are going to be reviewed. And when they are reviewed, if as and when they're reviewed,
So,
regardless of whether the application is approved or denied, when it's approved, I want to make sure that the reviewing court sees the progression of events in which at each separate occasion, the objector drop-shipped his objection after anybody could prepare answers. And I would respectfully suggest he does so intentionally. He did it in June with regard to the notice, and he did it today in regard to addressing the issue of the various members of the board that he has asked for recusal. Now,
okay, so let me address the overall issue. So first of all, we have an applicant's attorney, and we have Mr. Cohen, who's a pro se objector. So the objector is extended the same courtesies as the applicant regarding scheduling matters. I think that's consistent with municipal land use law. Also, Mr. Cohen had the opportunity to retain counsel, and he has decided, as many people do, not to retain counsel. I understand he's got a planner, but as far as legal advice, he's representing himself, and every right to do that. However, he'll have to follow the same rules as someone who's an attorney. So the reality is that whenever those documents came, if we were to determine that it wasn't timely, what really would occur was the matter would be carried. That's what would be carried. That's what would likely happen. I don't disagree with what Mr. Cohen said as to what is on the website and when it has to, addressing where the documents go. So while I don't think what he's done is different than perhaps contradicts, I should say, what's on the site. What I do not understand is, and I'd like to hear, one, why he did that the night before, and just as a professional courtesy, as the board attorney, I didn't get a copy. Mr. Cohen, want to address that?
Mr. Kittrick, I'm following the instructions based on your own agenda document. All files should go through Ms. Dicker, and she should disperse them. I should not be dispersing them. And quite frankly, I did it improperly the first time, and I sent submissions to Mr. Cannon in error. So I didn't want to make that mistake, and I followed the rules as per your agenda.
Well, Mr. Cohen, I don't know why you would give the documents to the borough attorney. I mean, you're before the board of adjustment.
That was my error, sir. That was not this meet. This was before the previous meeting.
Right.
And Ms. Dicker was nice enough to give me the proper direction and state that he was not involved in that case.
Right. So you understand that when these documents are presented, they have to be reviewed in a timely manner, right? So I think I'm going to call it a courtesy that I think most attorneys would follow, that you would give people notice ahead of time. You didn't do that, and we're not going to hold up the proceeding on that. But
I don't expect you to, sir.
But you need to give people more notice.
Well, I would advise the borough to change the notice for the Zoom then. If people read this, I followed the rules.
Yeah. So
I would like to make Mr.
Now, please. Now, I don't know where we're going with this, but in the future, if you have some documentation, I would expect that you give it to your adversary and you give it to the attorney of the board in a timely fashion, and not the day of and the night before. Okay?
Yes, sir. I understand that.
May I just comment briefly on that, Mr. Kitcher?
Sure.
Those of us who practice municipal land use, we're confronted on any given application. We could be the applicant's attorney, or we can be the objector's attorney. And as you pointed out, the record should be clear. Any person has a right to be a pro se litigant, but they're held to the same rules that you and I would be. And you use the word professional courtesy, and I think that's a good term. But I think the record should reflect that if the course of conduct sets up a history, that each time that there's a meeting, on the eve before, not even the day of the meeting, the night before at 8 o'clock, he communicates it to the board secretary, well knowing that she's not going to be able to disseminate it amongst the board members, who certainly have a right, particularly under some of the assertions made in this transmittal. And that should be done so that if it's appealed at some later point, the record should be clear that on each occasion in which I appeared, it was a late submission by Mr. Cohn to somehow delay this process from taking place. Now, with that said, let's move ahead. I would like him to raise each one of his items. And to each one, we can have a colloquy. I will respond to it. I can answer it. I will defer to the board, a board attorney. And then as we go through the process, we can make decisions on each one, or not me, but the board and the board attorney can make a decision on each issue that Mr. Cohn raised. But
Well-
I'd like to hear from him, not through a written transmittal. What are his problems? What are his objections?
All right, so I just want to make sure everybody can see the submission.
Well, this is Dave Critelli. I can't scroll down the submission at all.
No, because I do the scrolling. It's my screen.
Okay.
Okay. All right,
Mr. Kittrick, I just had one aside there. is
sure.
that I've attended a lot of meetings and I've been handed engineers' letters the day of the meeting in the forum. So I don't understand why now I'm held to this standard when other professionals have done that to me before. I mean,
Done that, what do you mean, done that to you? I don't
where
know.
I've been handed an engineer's letter the day of the meeting.
In what capacity?
As an applicant. So, I mean, I
I
don't
mean,
know.
I can't comment on your prior history. You have, but we're talking about this board.
I totally understand, sir.
Okay, and you have to have standards. Listen, I accept that you looked at the website and you believe that you were following the procedure.
Yes, sir.
I accept that. And but going forward, there's got to be courtesy extended. That's how we conduct here.
Yes, sir. I understand.
Because if you want to be a cynic, it looks like someone was trying to get it late so people don't have the opportunity to prepare. I accept that was not your intention. I accept that. But, a cynic would think that is what's going on. So I accept that that's not what you're doing. I totally accept your representation. But moving forward, if we are moving forward, we need to extend each other professional courtesy. Okay?
Yes, yes.
Let the record reflect that I'm the cynic in the group.
Okay. All right. So I'm looking at this, Mr. Cohen.
Yes, sir.
So let's just start with number one.
Sure. Well, it became readily apparent after reviewing the video numerous times that this testimony, and it is literally testimony, was entered onto the record by a board member, leaving many, many facts that would not come in the meeting because there was no testimony in the meeting. So how would she know that it was a lighting and safety issue? She states that she's familiar with the structure. How does she know it's a safety issue? I mean,
Can I interject? Since you're
these were-
talking,
Well, let it,
then I'll tell you my opinion.
let's
My neighbors.
have,
Mr.
I
Kittrick,
appreciate that, Mr. Cohen. You proceed, Mr. Cohen.
what I'm interested in is Ms. Phillips' opinion after she hears the facts. So clearly she came to the proceeding, schooled about this, having intimate knowledge that she received somewhere. And
Not true.
it was, please, Mr. Kittrick, can I finish?
Not-
Well, let him,
You're
Deidre,
talking
just let
about
Mr.
this.
Cohen finish. Let Mr. Cohen finish.
Go ahead.
Mr. Kittrick, Mr. Stone offered no testimony and swore in nobody to give testimony but a board member decides to give testimony and shouts it out to the other board members. It's highly improper, and the only answer is for her to recuse herself.
Okay, well,
Any perception of a conflict, and I perceive a conflict as many other people who viewed it. So a perception of a conflict, sir, is a conflict.
well,
You opened it.
Ms. Phillips, let me respond first, okay?
Okay.
All right, so I'm not sure that's true. The perception of a conflict is a conflict. I'm not sure that that's accurate, but let's talk about the specifics of this. In this, you're saying, you're referring to this as testimony.
Yes, sir.
So
You said that nobody had seen it. None of us that we are.
Deidre, let me just get through this, okay? And then,
You opened it up.
okay. So, how is it, are you, I think what you're saying is a statement. I mean, the testimony is stated under oath. So this isn't.
It's absolutely testimony, sir. I'd be happy to read it right now for everybody.
I have to interrupt. May I interrupt, Mr. Kitcher?
No, I'd like people to stop interrupting, actually. So I'm not saying you can't read it. What I'm saying is, and I saw what you had, that's not testimony. That may be a statement, but I don't think you're characterizing it correctly.
Well, how would she know about what their daughter needs, sir?
Do you know what testimony is?
Yeah, I know what testimony is. That was testimony in favor of the application before.
Tell me what it is. Tell me what it is. Tell me what testimony is.
Testimony is statements entered into the record in a legal proceeding.
Under oath.
Oh, okay, so she wasn't under oath. It's still improper for a board member to enter this onto the record, whether she's under oath or not. She has a preconceived notion of the way the application should go, and she broadcasts that notion to the other board members.
So I'm not disputing what you're saying, other than I was clarifying. I want the record to be clear. That's not testimony, okay? So that's not what that is. That's not what that is. But I understand your point, and we'll address your point. So you say, so you have attached a transcript that you prepared, right? So is that transcript, so my question is, who prepared it, and was that from the meeting?
I'm very clear to state, sir, that I typed it based upon the video recording, which is available to any board member or any other jurisdiction beyond this one.
Okay, so after the meeting, you viewed it and typed it up?
Times, sir.
I couldn't hear you. I couldn't hear you.
Oh, numerous times.
Okay.
I viewed it numerous times, sir.
Because it remains, I'm just curious, it remains on the website after the meeting? Is that?
No, I actually inquired to Ms. Stickert, and she sent me the video recording link.
Got it. Okay.
So I could watch it.
Just trying to understand how you
I
got
believe
it.
she'll
Okay.
confirm that.
All right.
Now,
So-
Mark, you wanted to see the transcript that he prepared, or yes?
Please.
I object to that.
Okay, what's your objection?
Okay, a couple of things. Number one, may I respectfully ask that since Mr. Cohen has given this information to the board, that he be sworn in so that he
Sure.
he makes these statements under oath?
Yes. Mr. Cohen, since you're not a lawyer, you would need to be sworn in. So you swear or affirm to tell the truth, the whole truth, and nothing but the truth tonight's proceeding.
Yes, I do.
Thank you.
Mr. Kittrick, I'd like to direct a question to you to ask Mr. Cohen. I don't want it to appear on the record that I'm cross-examining Mr. Cohen at this time. That may happen later on, but I think in the spirit of this dialogue, it would be better if the questions came from the board attorney. I'd like to know whether or not the transcript that he provided, to which I object, is a verbatim record, and is he certified as a court reporter or otherwise to provide such information to the board?
Okay, so Mr. Cohen, you heard that. Sure.
It is prepared to the best of my ability, and the backup documentation is the video itself.
Okay, so I object to that. That has no place in this record. It's not testimony, it's not certified, and he's not qualified to take a verbatim record. I'd like to ask a second question. I'd like to know whether or not during the course of the last meeting in June, did he tape the meeting himself?
No, I relied on the borough's copy of the meeting, and I made multiple requests as to why it wasn't posted on the borough website for the rest of the public to watch. I had to take an extra step, do an Oprah request to Ms. Dickert to get a copy of the link to watch it. I would much prefer to be able to watch it at my leisure attached to the website, but apparently that's not the way it works.
I don't believe by law we're required to post videos. You're entitled to an audio recording.
But I mean, the planning board has no problem with it. The council has no problem with it. So I don't know why it's a problem for the zoning board, but you know, I'm all about public information. Let's just put it out there.
Let me make another comment, Mr. Kittrick. Well, it's not unusual after an applicant provides a application to the board that the board members in preparation for the meeting review the application, attachments, reports, plans. In fact, that's the very essence of the municipal land use statute, that the board members have an opportunity. So on the outset of a meeting, it is not unusual for board members to have a dialogue about it, but make no decision until all of the evidence in, both for and against. So the fact that, now I don't know this particular board member, but the fact that she made a comment from what her review was, I don't find that objectionable, and it's certainly no reason for her to recuse herself. In addition to that, I would respectfully suggest that if there's such an issue, the next question that should be raised is whether she can be fair, unbiased, and form no preconceptions. And if the board attorney is satisfied with that, then that should end the issue there. And if Mr. Cohn has a problem after the application is completed, he can take that appeal up to the Superior Court Trial Division.
So I think it's helpful at this time to hear from Ms. Phillips.
Okay, and I think to reiterate that, I'm absolutely fair, unbiased. I don't pretend to be an attorney or a planner or architect. I'll listen to the testimony and then I make my decisions in conjunction with the rest of the board. Furthermore, I was saying a question. They're my neighbors. I've seen the structure. And I know that the daughter is a doctor. Like I know other cases that have come before. They're neighbors of mine. Doesn't mean that they're going to like what I think, whether I vote for them or against them. But I think I can absolutely remain unbiased, fair, and come in with no preconception about what my final vote will be.
So I think, so I appreciate that. And I saw what Mr. Cohen had presented. And you made reference to, and I'm paraphrasing, so please excuse me, but
Okay.
something about them needing two doors, something along those lines.
Well, in my mind, again, do you need to have two doors for a two-car garage? You would think you would. And I raised the question. I didn't know if you do because I only saw one door. But I've seen pictures with the two cars in them, like we all got pictures on the board.
So have you prejudged the application?
No, I have not.
All right, and do you have a relationship with the applicant, which would
No, I really don't think so.
impact your impartiality?
I would definitely say I'm impartial. I say hello. I'm not in the house socializing. I see them when they're walking the dogs and their kids and I say hello. That's the extent of my relationship with the Cotlers. They're very nice people. I supported him when he ran for mayor, but that was many years ago. Other than that, no, I really don't have, again, I'm impartial. So whatever you think, that's how I feel about it.
Mr. Cohen, you have any comment?
Well, sure. I'd like to know if she's ever been in the structure. So she says, so I guess knowing this structure for myself, they have to have 2 doors.
I've
How
never
would
been
she
in a
know the
structure.
Has she ever been in the building?
No,
And how would you know about the applicant wanting lighting and safety for their daughter if there was never any testimony to that effect?
Mr. Kittrick, I don't think it's appropriate.
I asked the question.
I don't think-
Yeah, so this isn't you don't get it applies to Mr. Stone. This is not a cross-examination of Ms. Phillips. So the question, and I'll ask the question. You've already stated you were not in the inside the building. But would it be fair to say with applications that we've had previously, have nothing to do with this application, that you and other board members will sometimes go to a property to look at it prior to the meeting to get an idea of what?
I do that all the time.
Right.
You know, I do that with particularly one of my pet peeves, as you know, is the air conditioning unit placement.
Right.
Silly as that. I've been voted, you know, I vote against it and been outnumbered, but hey, I feel strongly about certain things. The minimus factors of the solar panels on the top. We already know from literature that we got regarding this. But no, in terms of them wanting a safe structure, that just goes without saying. I mean, I had no conversations about it with anybody.
All right. Okay, I have enough information. Let's go to number 2.
Sure, that would be a business relationship, and I understand there are HIPAA laws, so it's not anything that I can ask about, but the board members should volunteer by recusing themselves. There's nothing more intimate than that relationship between a doctor and a patient, and you know, if you're going to be making a decision about your doctor, you're in a very awkward position, and I believe the best thing for the public is any members, as I request, who are have that relationship should simply just recuse themselves. I'm not here to beat anybody up, Mr. Kittrick. I'm just asking simple questions to get the smoothest application here for Mr. Stone.
Okay.
He's
can
not
I-
my doctor, by the way.
Wait a minute, can I enter? I have a question about that. I
Sure.
want to know whether or not Mr. Cohen has any information to suggest that any of the board members are in fact patients of Dr. Cotler.
No, sir, I have nothing to lead me to believe that. I'm just asking the question and leaving it up to the conscience of the board member because there are HIPAA restrictions. So they can, that's why I ask in my letter for Mr. Kittrick to poll them privately. It's their information. But, you know, the public should get a fair and honest hearing. That's all I want as a public citizen, sir.
So, Mr. Stone, and without prejudging this, I mean, I have no idea who's, like yourself, I don't know who's seeing which doctor. But let's assume for the purpose of this conversation, Mr. Stone, that there is a member or there are members of the board who are patients of the applicant. What's your position on that?
You know, I all day today after receiving this transmittal and that paragraph dealing with patient information, it's very troublesome. I'll give you an example. Suppose you take your board one by one, just as if you were the judge in a trial out in Freehold, and you wanted to voir dire each one of the various jurors, and you wanted to do it in a private setting. Now, we've tried cases in Freehold before juries. I know I have. And once in a while, either you go to sidebar, everybody whispers, but once in a while you go into chambers and the judge brings the lawyers in, and in front of the attorneys, the judge asks very delicate questions. In this case, I think you fill that role. So But let's assume that you took your board out one by one into one of the meeting rooms, and then they proceeded to come out to back to the dais, and one of them leaves. That would allow the public, Mr. Cohen, and all of the other people that are now visualizing this proceeding to know something very private that Mr. Cohen would be getting indirectly that he's not allowed to get directly. Now, if he were to say, are you a partner with Dr. Cotler? And it determined that one of the board members was a business partner, that's different than the very sensitive relationship that will be exposed to the world if Mr. Cohen gets his way. And that issue is very sensitive. So he can't get a HIPAA form executed. He already indicated, to his credit, that there's HIPAA sensitivity, but he wants to know who Dr. Cotler treats. He's not entitled to know that. Nobody's entitled to know that. So when we place members of a community onto a board, we trust that if they feel as though they can't be honest and fair, then that is within their conscience. But if they're asked that question, can you be unbiased? Will you be prejudiced in one favor or the other? And their answer is the negative, and we have to accept that. Mr. Cohen is not entitled to the answer as to whether or not any of these board members are patients of Dr. Cotler. And that's my position. So I don't think he's entitled to that information.
Mr. Kendrick, if I may, this can be done very simply. The board members can just recuse themselves. There's nothing here, but to have a business relationship with someone that you're going to vote on their application, I find that very troubling, sir.
I think you're both saying the same thing. By that, I think you and Mr. Stone are just saying it a little bit differently. That a board member, without having to announce what the issue is, could recuse themselves, knowing about the standard, okay, if you will. So I would think that would be the way to handle it.
I don't disagree, sir. That's all I asked for.
Yeah. Okay. So let's
not decide that. May I suggest that we not?
No, we're not making any final decisions on anything right now. So, number 3.
Sure, Mr. Kendrick. Number 3, I find is very important because Mr. Waterman writes the denial for the application. And in any other forum I've been in, they supply the zoning officer to answer questions as to why the denial is the way it is. In this case, there is a history of denials on this same structure before they were granted the approval to build it. I would like to know more about the history of that. I would like to know what those plans look like, and I'd like to know why they were denied. And Mr. Waterman is the one who wrote the denial, and I feel that I should be able to cross-examine him as Mr. Stone. Mr. Stone may have questions about the ordinances intimately, and he may want to ask Mr. Waterman. So, I mean, I believe Mr. Waterman should be supplied for this hearing. I would hope he's on the call.
I don't know if he is or not. May I provide you? So what I think that Mr. Cohen is alluding to is that he wants to bring in Mr. Waterman for all of the history leading to the approval. I would respectfully submit that all that led up to that approval would merge into the approval. And once it was approved, if Mr. Waterman is to testify as to what happened post-approval, I certainly have no objection to that. He certainly, but if Mr. Cohen is going to go back into the history of this property for the last 10 years, what led to the approval. At the time that Mr. Waterman would be provided for his testimony, I would raise that objection. So whether or not Mr. Waterman comes or doesn't come to the meeting, that would be determined as the meeting was progressing.
You light up.
That being said, I'd like to say that, there was an approval granted to build a garage apartment, and that didn't happen. And I'd like to talk to Mr. Waterman about that application, and as you say, Mr. Stone, the subsequent application, which was denied. I have multiple questions on the denial.
And you know what? Mr. Waterman, he's not my witness. I don't suspect he's your witness. If the board found that it would be appropriate for him to provide information to the board, for him to assist them in their decision, provided that we don't go back into the history pre-approval. Once it's approved, then if you want to talk about what happened after that, of course that is part of full consideration. In fact, you know, Mr. Cohen, that's the reason we're here. Because if the structure was completed in the identical fashion to which it was approved, there would be no objections to this application.
Oh, I don't disagree, sir. That's all I'm asking for.
So I have no problem with Mr. Waterman, but I would respectfully submit to Mr. Kittrick that the issue about the extent of his testimony and what it covers, that would be dealt with just as it would with any witness in any trial setting or any board meeting. When he testifies, there'll be issues, whether there'll be evidential objections or otherwise. That's not something that should be dealt with here.
All right. Any other issues?
Yes, I have an issue. So along with Mr. Cohen's package, I was pleased to see that he found and submitted to the board. I should tell, for those board members that may not know, I was the zoning board attorney in Bradley Beach for what I believe was over 2 decades. And during that time, I acted in the same capacity as Mr. Kittrick. And a few years ago, I decided that the winter night meetings were too much for me. But here I am. And he provided a copy of a resolution. The application was for a Joseph and Jacqueline Jankowitz, along with one of my bills to the Borough of Bradley Beach. I'd like to know what his point is. What was his issue to provide that to the board?
Oh, sure. That goes to the arbitrary and capricious nature of this application, sir. And you will hear testimony about that.
I want an explanation of that. This would suggest that he called out of all of the records that I had over a 2 decade period or more, he decided to bring this bill before the board, which I think is irrelevant, immaterial, and presumptuous. I'd like to know why he gave this bill to the board.
As it relates to the legal review for that, and that case, 507 4th Avenue, they requested a garage bathroom. And I submitted the original plans when the garage bathroom was proposed. Through the hearing and in the resolution, it indicates that the board did not approve that. And there's a letter from Mr. Frieda also, which states that Mr. Jankowitz removed the bathroom from the plan as condition number 1 of the resolution. And I entered that into evidence because this applicant is asking for a garage bathroom. And I consider it to be an arbitrary and capricious standard if the board approves that. So that's why I entered that into the record, sir. And it just so happened that you did the legal review, which I just found interesting. If you'd like to strike that from the record, I would have no objection, sir.
No, I'm very proud to have been the board attorney for the zoning board of Bradley Beach. So I have no interest in striking my. Okay, but let me suggest this, and I'll defer again to Mr. Kittrick. Regardless of whatever happened on any other application, under any other review standard. None of that is precedent in the application before the board. Every case stands on its own 4 points. And in this application, it will stand on what we're going to provide to the board, which includes the bathroom, the washer dryer, all of the comments that the engineer made, we are prepared to address. But the issue as to whether or not the board should retain jurisdiction of this is an issue that I will raise after Mr. Cohen completes his discussion.
Sure. My last one was, yeah, I made the recommendation on the first meeting that we do a site inspection, and my recommendation was just kind of dismissed. It's a very unusual application here where the building's already been built. We're not just working off of some plans. I mean, we can actually go inside, see the operation. I think it's a very unique opportunity, but I made that recommendation in the video and it was just pushed aside based upon I guess the misnotice arguments. But I'd like to know why no one called me to schedule one.
Well, I will raise a point. A site inspection is unnecessary. There are as-built plans showing what the buildings exist today. The plan as proposed is pretty clear. And I think that frankly, a site inspection in which we parade people onto the Cotler's property is inappropriate. It approaches harassment. It's unnecessary. The board will have plenty of information in order to make an informed decision as to what the conclusion of the application should be.
Well,
and this application is no more unique than all of the many, many applications that have occurred over the many decades before the zoning board and the planning board of Braley Beach. The board members are very capable, in my opinion, to review, analyze, listen to, evaluate, and conclude an opinion based upon what has been presented both for and against the applicant.
Mr. Kittredge, as Mr. Stone stated, every application stands on its own. And this one is unique on its own because the building's already built. And there should be no reason that the board members and the public can't have an organized site inspection. So again, I'm going to stand on that. I think it's very unusual. And there's a wonderful opportunity to really get just site information for the board members so they know exactly what they're voting on.
So without making any sort of decision on that, it would be highly unusual if we did that, highly unusual. And, one of the considerations would have to be, we're in a pandemic right now, and the health and the safety of all individuals involved in the application is paramount, so.
This is Dave Cortelli.
Wait a minute, especially the board members. So.
This is Dave Cortelli. I'm sitting here listening to all these conversations, and I'm just a little bit confused as to why this is going on for the period of time that it's going, where we have somebody who's trying to improve a community, improve the town, who has been a long-standing member of this town, and we're lambasting them for, I'm not sure what reason.
Dave, so right now, we're going through some issues before the board has taken jurisdiction. We have not taken jurisdiction. So to answer your question, we're working our way through issues before we get to the point where we accept jurisdiction. So
Can I ask a question? How long has Mr. Cohen been in town?
I don't think that's relevant right now, Dave. So if we could just conclude this and then.
For the record, I'd like to say that I have owned property here for 20 years, 25 years.
All right. So I think we need to conclude resolving issues in the case before.
Okay.
Okay.
So
Richard?
Catherine Hossley, I just have one question. At the end of the meeting,
We're not taking questions right now. We're working through these issues right now. So,
gotcha. Okay, thank you.
Mr. Stone, did you?
I think that I think we have to make some decisions, but Mr. Kittrick, what's your pleasure? What are your thoughts?
Well, do you have any, I thought you indicated you had an issue that you wanted to raise.
I may not need to. May not need to. It depends upon what happens now, considering Mr. Cohn's positions. You know, when I gave thought to these things early in the day, it was before I really heard from him to see what his problems were. I want to know, can the board hear this and do it with, can the board in its present configuration hear this application without being biased and allow the process to move forward? I tell you, I will concede, Mr. Kittrick, these issues that are being raised are troublesome. And I know that you said early on that, and Mr. Cohn pointed out that apparently, according to the website, he was within his right to bring this issue up at the last minute. You know, I wanted to comment, you know, we lawyers who practice in this field, we very often, even when we're against each other, we extend courtesies to each other. And if Mr. Cohn had these issues, which were clearly available to him a month or more ago, if he were a lawyer, he would have either called me up and said, Richard, I got some problems, I'm gonna give them to you. And I would have been prepared instead of having to run around today trying to prepare for these questions. And that's why we're taking up the time of the board members. We should be already moving through the application. I should also point out to you that on this video or this Zoom meeting, all my experts are available. My engineer, my architect, my planner, my clients, we're ready to go. But to put a taint of some impropriety on an application that should have moved forward in June is unfair. So I don't know, I really have to defer to you as I would to a judge as to know what you think we should do. And of course, I will discuss it with my clients and I will do what you think is the right thing.
Well, I don't understand what you mean by what you think we should do.
Well, if the board members are not going to recuse themselves, let's get going. If some of the board members, I'm very uncomfortable about that because everybody now that's on this Zoom or will read the transcript or watch the video as Mr. Cohn did, they're going to know that anybody steps down is a patient of Dr. Kotler. Now, Mr. Kittrick, are you entitled to know that? I don't think so. I don't think any of us are. But we have to leave in the best judgment of the board members that they will be fair and unbiased for whatever their reason. Maybe they don't like the way Dr. Kotler practices medicine or the way he keeps his garden. If they feel as though they can't be fair, then that's within the conscience of each of the board members.
So this is a extremely sensitive and important issue. And here's here is one of the problems with dealing with it the day of. What is the legal guidance on this, Mr. Cohen or Mr. Stone? What's the legal guidance here?
Okay, so I want to put something.
Can either one of you provide a case to me in either direction as to how we would make this determination?
I would defer to Mr. Cohen first since he raised the objection.
Kittrick, I'm making a simple observation, and I made my case clear. There may be case law. I don't have access to LexisNexis, so I don't have it.
Yeah, so it's not a simple observation. It's not a simple, it's actually a pretty complex one. You know, Which presents a problem when it's presented at the 11th hour, because everybody wants to be treated fairly. Both, the applicant, the board members, the public, the objector, and you've raised an extraordinarily sensitive issue, and I think it's relevant, but it's extraordinarily sensitive. And to make a decision like this in the middle of a meeting with, I want everybody to appreciate, you have our board secretary who, this is not, this case is not her only activity today. I'm your board attorney. I spend a lot of time doing the work on this board, but I have other responsibilities during the day. And that's why people, and you want to be able to do a good job, and you want to be able to give a sound legal opinion. And the fact that, Mr. Cohn, you don't have access to LexisNexis is that doesn't cut it.
Okay.
You're representing yourself, and that's fine. But if you're raising these issues, and this one is relevant, what's so
Well,
what's the legal support?
These are common sense issues which should have been brought up to the board members when the application came in. That could have been done internally. I mean, obviously there's a potential for conflict. I mean, there's been previous cases of conflict in Bradley Beach.
We're here about this case.
I realize that, sir, but conflict in a small community is an issue, and especially in this case. So,
no kidding. But that's not what we're talking about here. This is a HIPAA issue. That's very unique.
Mm-hmm.
Very unique. This is not just a simple conflict issue. Now, the issue you raised at the beginning, the transcript issue. Okay, that's not an unusual type of conflict issue. But what you're presenting here in this part of it, it is very unique.
Okay.
And very, very sensitive.
Mm-hmm. I agree, sir.
Right. So what is what's your legal argument? What are there cases supporting your position?
My case is that they have a business relationship. If they have a business relationship,
Who
they
does?
should recuse themselves. That's all.
Do you know who has a business relationship?
No, I've stated that already. Under oath, I've stated that already. I do not know. I just raised the question, sir.
Right. And I'm telling you, it's irrelevant. I agree, it's irrelevant. But getting the answer to that, it presents complications that you don't see in other conflict issues. That's the inherent problem. And you've already addressed the HIPAA aspects. So I'm certainly not going to do something tonight which is going to violate anybody's privacy. And I don't think anybody here wants that to happen. We all in agreement about that?
Yes.
Yeah. Okay. So I get back to, I can tell you there are responses, but the response common sense, that's an evasive response. Do you have, and it appears that that you, Mr. Cohn, you don't have any law supporting direction one way or the other on this.
No, that's true, sir. I don't.
Okay.
I leave it up to your legal mind.
Yeah, I know. I appreciate that. But my expectation, I have to call balls and strikes, right? Somebody's got to call balls and strikes. And it's not good enough for you to raise the issue and say, okay, let somebody make make the decision. You have to have a legal argument. You're not once again, I'm saying you don't have any cases supporting or giving guidance one way or the other. Now, imagine a scenario where this issue was raised 10 days ago, and the parties would have the opportunity maybe to do some research on it, review it. But that didn't happen here. And that's the problem with providing something like this the night before. That's the inherent problem. But, we're dealing with it, so we will deal with it.
Mm-hmm.
Mr. Stone, do you have any
So,
direction on this?
I'm going to throw another fly in the ointment. And I see, I don't know how this exactly works, but I see that people are typing in. Is that,
Yeah, I know.
does that usually happen? I don't know how that happens. I saw somebody typed in,
Yeah.
he's not a lawyer, so you don't have to hire a lawyer.
So I don't know what we can do about the chat, but it's also distracting.
I just want the public to understand
Yeah.
that it is true that we are trained as lawyers, and of course, the skill of a lawyer is being able to research, but anybody has a right to represent themselves. And Mr. Cohen certainly, and I've never had any dealings with him before, I don't think, but he seems to me to be a formidable adversary. He's prepared, he's articulate, and I'm not just complimenting him, but that doesn't make him correct. And if I were on his side and I made the issue, I raised the issues that he raised, I would have to support it. That's what a lawyer's job is. And if you choose to represent yourself, then you still have to do that. However, if this issue doesn't complicate the case enough, the issue of the undercurrent of politics is even worse. When this application was first filed, and again, I'm making it for the record because I anticipate this record is going to be reviewed. When the application was first filed, Dr. Kotler was a sitting councilman in Bradley Beach. Clearly, as a sitting council member, the Board of Adjustment or the Planning Board or the mayor and council couldn't hear those cases because there was a very clear conflict. And that could work both ways. If it were heard by the zoning board and the members of the zoning board favored the other side of the political line, that would be one conflict. And similarly, if there were those who favored his side of the politics, that would be inappropriate as well. So that existed, that conflict existed. And as a result of which, the case was transferred to the contiguous municipality, Avon. And at that time, I believe, I forget if I communicated with the board secretary there, but I was anticipating that as the application was progressing, that it would, and it would be heard there. So I see there's other chats here. The people are already chatting, but that conflict, while he was a sitting council person, has not disappeared. If this application were to continue before this body, I think that the conflict that existed before he lost the election could very well exist after he lost the election. So I'm as interested as Mr. Cohn is that that Dr. Kotler receive a fair hearing. And the board members also have to reflect upon their own conscience to make sure that whatever line of politics they're on, either now or in the future, that they'll give them a fair shake. So as we approach these very sensitive issues, I'd like to get over the first issue first. That's the one of the disclosure of what would otherwise be confidential on the HIPAA. And then revisit the issue later as to the second part of it, because it appears to me that this is going to take some time. Am I wrong about that, Mr. Kitcher?
Well, I didn't understand. What do you mean, revisit what?
Well, at the time that the board members make their decision as to whether or not they're going to be intact as a board, then we'll take a look at the issue as to whether or not the board as a body can be unbiased. And if they can, and there's no reason to remove this case from Bradley Beach. But if some of them feel as though because of political motivations, they can't be, then for those reasons, they may be, need to be
Well-
removed.
If I may, Mr.
Go ahead,
Kittrick,
go ahead.
it has nothing to do with politics, sir. He's putting his own testimony on there. This is a municipal land use law issue. This is not a political issue at all.
Yeah. And you
Well,
know
so-
what you know what I would say to that? What I would say to that is that when the board is intact and ready to proceed, I too may want to question them through the board attorney as to their prejudice or lack thereof.
If this is a municipal land use law, why are we even having a conversation about HIPAA?
Well, that's because Mr. Cohen brought up something that would violate, he brought up the.
Not, isn't HIPAA a federal law, not a borough law? And why are we having this conversation?
Well, okay, so Dave, the reason this is coming up is because there's a question of whether a board member has a doctor-patient relationship with the applicant, and whether in fact that relationship results in a conflict. And the sensitivity of determining whether such a relationship exists is governed by HIPAA, and so that's the conundrum.
Mr. Kittrick, can I make a suggestion?
And just one thing, federal law would preempt. Go ahead. Yes.
You have two situations where there can be bias. Bias under the doctor-patient question, or bias based upon the political question.
Right.
If we present to the board a chance to recuse based upon either one, you should possibly be able to give the fig leaf to cover the HIPAA. I would suggest that you don't bifurcate it and you do it all at once. And that's just merely a suggestion from myself.
Okay, that's a good suggestion. So if I could just elaborate on an argument that Mr. Stone made. So here's my understanding before this application got here. While the applicant was an elected official, there was a need for some level of inspection regarding the project. I don't know all the details, but when that was occurring, the inspections were handled by the Borough of Avon by the Sea. That's my understanding, and that's not unusual because there's whoever would serve the role of inspector would be an employee of the Borough. So it went to Avon. But it's not clear to me that meant that once that was done and once whatever decisions were made regarding those inspections, that the application would have been heard by Avon. It's not clear to me. So there are cases that say one, and one is a Superior Court case, Wiskowski versus Rezas, NJ Super 28, 1992. And I'm gonna just summarize that's a situation in which the elected official wanted their matter to be heard before a municipal land use board. And there was pushback regarding that. And the ruling is that procedures have to be put in place, but the mere fact that you're an elected official does not prohibit you from having an application be heard by that municipal land use board. Now, I'm giving a very general observation here, and there are always restrictions and guidelines in doing that. So that's a different situation, and I'm not trying to put words in Mr. Stone's mouth at all, but this potentially would be an issue, would be a situation where perhaps the applicant would be saying, I don't wish to be heard by the land use board in this municipality, or this ex municipal official. So there's a little bit different spin on that. Okay, so I'm not, I'm not, a cursory review is, I haven't seen any cases where it's taken out of the municipality. Doesn't mean they don't exist. If there are conflicts within one particular land use board that people can't hear, oftentimes members from another board in town, in this instance, the planning board, could enter into a situation and so that there'd be enough for a quorum. Of course, in this situation, you may be dealing with the same conflict issues. So anyway, so Mr. Stone, I agree with Mr. Afuso that we should deal with all of that at one time. I think that makes perfect sense.
I don't object. You know what? I don't object to that. I mean, look, we have to cover the record. We have to make sure that we get support to make for you to make the right decision. I have no objection to that.
So, I don't want to, since we're having discussions about conflicts, I'm trying to, as we're discussing these, I want to get everything on the table. All right. So here's something that is occurring to me as we're discussing this, and I'd like Mr. Cohn and Mr. Stone to address this. So, because I don't want to address it later. You're before the Borough of Bradley Beach Board of Adjustment. The members of the Bradley Beach Board of Adjustment are appointed. It's a mayor's appointment. Typically, the mayor's appointment is done, not always, but done at a reorganization meeting, whereby it's part of a consent agenda that the council would vote on. So, arguably, the members of this board were appointed in that manner while the applicant was an elected official. Anybody have any position on that?
I was not.
Okay.
Well,
so there are members that fall in that position, perhaps not all, but I know there are. So, Mr. Cohn, you have any position on that?
I mean, I like what Mr. Afuso said. I mean, that made sense to give people the opportunity. And
no,
so,
that's a different issue. I agree what he said made sense, but this is a different issue.
I mean, that's up to the board members. I mean, I don't.
No.
I'm not objecting to anything that has to do with politics at all, sir. That's not at all.
And I'm not talking about politics. What I'm saying is that there are members of this board, and I'm telling you, I think you're somewhat familiar with the format, that members of the board are appointed by the political entity in town, correct?
Those are mayoral appointments.
That's what I said. That's what I said before. That's what I said before.
With council approval. I'm not objecting to any of that.
So my question is, do you have an opinion as to whether that presents a conflict?
I don't view that as a conflict at all. That takes place in every single town. But if they don't feel comfortable voting on it, that's up to them. People have donated $50 to a mayoral campaign in the past and recused themselves because they didn't feel comfortable. That's up to them. I don't have any bearing on that. I'll leave that up to their conscience, sir.
Okay, so
I think.
listen, Mr. Cohen, you're representing a position. So, the response can't always be you leave it up to them. We'll certainly inquire more. I'm asking you, you're representing yourself. Do you have a position as to whether you're arguing that that's a conflict?
I'm not arguing that politics is a conflict, sir. I made my point about the medical issues.
All right, I'm gonna see. You're not answering my question.
Okay.
You're not, and I'm gonna.
Okay, try it again. Let's do it again.
Because this has nothing to do with this is the question is, do you take a position that there would be a conflict that if a board member was appointed to the board as a mayor's appointment during the tenure of the applicant serving as a member of the council, and that appointment by the mayor was ratified at a meeting under a consent agenda by the council?
My position is that this happens in 565 municipalities. The mayor makes the appointments. I have no issue with it at all, sir. So
your position is it's not a conflict?
I do not believe it's a conflict.
Okay.
Unless they feel it's a conflict because they made a political donation, that's up to them. But I didn't raise this issue, and I have no problem with this issue.
All right, so on its face, you don't view that as a conflict?
No, sir. There'd be conflicts every day all over the state if that was the standard.
I don't agree with that, but you don't feel it's a conflict. So, Mr. Stone?
Well, let's repeat the history. This matter had been sent to Avon. It was sent to Avon because Dr. Kotler was a sitting member of the council. After he loses the election, I don't believe that the conflict disappears. I think for the very same reason that it was sent to Avon and that Avon's inspector did the inspection, it continues. It doesn't evaporate because he lost the election. So in the hypothetical, had he won the election, it would have stayed in Avon. And that's where the proceeding would have been held. I might point out to you that the likelihood that if it was before Avon today, the very issues we're talking about now would not exist. And had Mr. Cohn not introduced this morning, I think that over the last, even if he gave it to me 10 days ago, a week ago, we would have been able to do a fair and complete review as to a response. And I also took a look at that case. It seems like it's the same case in reverse, right? Oh, I lost you. Are you still there?
Yeah.
I'm sorry. But I think it's the same case in reverse. But, as lawyers, we would have to research further. We'd have to draw some analogies from it. And all I want is for my client to get a fair shake. If Bradley Beach feels as though this board can give him a fair and unbiased decision, I'm ready to go.
Yeah, but okay, but I'm asking you the same question because we're going to get all this out now because we don't want to be addressing this later on. So one, Mr. Stone, I don't necessarily agree that it would have gone to Avon in the scenario that you're stating. I don't necessarily.
If I may, sir, the reason that it went to the building department in Avon is because the council has direct control over the budget
Yeah, I already went over that.
Okay.
I already established that. Okay. So, once the inspection issue was resolved, it's not clear to me it would have stayed in Avon. That's not clear to me. And I'm not aware of any cases where it gets, in a situation like that, it gets transferred to another municipality.
Well, so let me ask you, if he had won the election, you think that Bradley Beach would have still heard the case?
I think based on the cases that I've reviewed, if that was his desire, yes. Now, there would have been restrictions in that, and I'm not saying it would have been an easy road, and there may have been conflicts that would have had to be addressed. You may have had to get, perhaps, take members from the planning board to ultimately flesh out the board. But once again, and that's a distinction I made before, the case that I cited before, it's a situation where the elected official wanted to be heard, wanted to be heard. We're talking about a situation where what is now the former elected official perhaps would be asking not to be heard. And that's a different, those are different facts.
Then I have a solution. Let me put on my case. I'm ready to go. If the board is ready to hear the case, they feel as though they can give me an unbiased decision, my client and my experts were ready to go.
So you don't view that, you don't believe that there's a conflict based on the scenario that you're not arguing a conflict based on the fact that regarding the appointment issue.
I didn't raise that issue.
I didn't raise it either.
Mr. Cohn believes that there are members that should not sit in this hearing.
Yeah. Okay. I'm not asking anybody if they raised it. We're getting all this out of the way. So you concur with Mr. Cohn. That's not an issue, correct?
That is not an issue, provided that we proceed now. If we proceed now, I want to reserve my right to bring that up. If the board decides now that we're not going to proceed tonight, for whatever reason, then I reserve my right to raise any other issues that might have to come up. But right now, I am here tonight to present my case. And if it wasn't for Mr. Cohn providing this to us this morning, in fact, the board members didn't even get this until tonight. We wouldn't even be wasting 2 hours. I would have put in 2 hours of testimony already.
Right.
Now, I'm being put into a position, being asked a question that I wouldn't have had to ask if Mr. Kittrick, if you and I didn't get this today, would we be even talking about this today?
But we are. This is where we are. So, there's a lot of things that happened today I wish could change, but having nothing to do with this. So this is where we are. So this is a very difficult format to be discussing these issues.
And I agree with that. I would rather be in that room having this discussion where from time to time we could speak together. But it's very difficult in a case, particularly in a difficult case.
Mm-hmm.
In a straightforward case, it's not that bad, but in a difficult case, it becomes more difficult.
Yeah.
But given that, I really have nothing else to add. If the board wants me to present my case tonight, I'm prepared to do it. If the board wants to reserve and make a decision, I'll accept that. And my client will have to understand that he's waited this long, going to have to wait a little longer.
So I'm going to ask that Mr. Cohn and Mr. Stone provide legal research on these issues.
So let's make sure that we're narrowing the issue. One, board members' recusal. Given,
Could you, Christie, could you show that
So
that list
Christy
again?
actually got kicked off the meeting and is trying to get back in. It's
Wow,
still
it's a rough crowd. Yeah. All right. So I don't know if you could do that, Christina, just so we don't miss anything. That's why.
you know what I'm going to do, Mr. Kittrick? Tomorrow or Monday, I'm going to order a transcript of this proceeding.
Okay.
And unlike Mr. Cohen, I will be happy to share it with him.
Thank you, sir.
Yeah, ordinarily, I suggest that we share the cost of that. Are you okay with sharing the cost of a transcript?
Could you give me an over-under on this?
It's only about 2.5 hours, so it'll be.
Yeah.
But in fairness, I think that we should get a transcript. And what I'll do, Mr. Kittrick, I'll be happy to supply it to you at no charge.
Wait, I'll go a third if he goes a third.
We can't negotiate that. We got to provide it to Mr. Kittrick.
Yeah. Right.
But I want to make sure that we've narrowed the issue. As I see it, there's two issues. The HIPAA sensitivity, that should be an interesting one for us to research, and whether or not once the matter is transferred to another municipality, is it supposed to stay there, given the very unusual facts of the case? You
I
think
agree, sir.
And I also want you to address the Ms. Phillips conflict issue.
Oh,
Sure. Was that me or Mr. Stone?
Both of you.
Sounds great.
Yeah.
okay, now, can I give you my schedule, Mr. Kittrick?
Well, it'd be better if you gave it to Christine, or Christy.
Let me just explain to you my issues. As a result of the COVID-19, all of my pre-planned vacations for the first 7 months of the year were canceled, much to my wife's chagrin. I anticipate being away for about 2 weeks from Labor Day through the following week. So I know that my client's not going to be happy about it, but I'd like to put it on the October meeting. Can you tell me?
That's why I need Christy.
Oh, yeah. So may I make a suggestion?
I think it can be, I'm going to butt in. From what I say, October 15th meeting is okay.
So, Mr. Chairman, just so they're aware, that Irvington Manor is going to be on the 15th.
Oh, yeah. They were supposed to be on tonight as well.
Mark, I have Christy on the phone, and she said there's no one on the October meeting right now. She can't,
except for Irvington Manor that we just carried tonight.
except for Irvington Manor, which we just carried. She can't
If they renotice, they have to renotice. So.
It's your call, Mr. Chairman.
I would say we put him up first on October 15th at this point. Carry without notification.
This matter.
This matter only.
Okay.
Cutler matter continued.
All right. So,
With all
can I supply you with a brief by the 30th of September? That'll give you a full 2 weeks to digest my brilliant and articulate argument.
Mr. Kittredge, is that okay with you?
yeah, I'm
Gives you 15 days.
thinking about my schedule too. Okay. Both parties by September 30th.
Yes, sir.
All right.
You understand that, Mr. Cohen? You have to give a brief?
Yes, sir.
So So the transcript will come obviously sooner than that. And then here's what I would ask, just provide when you do that contact numbers in case prior to the 15th, that there's a discussion among, there needs to be a discussion among Mr. Stone, Mr. Cohen, and myself on the legal issues, not the facts of the case.
Yes, sir. Just the legal issues on those.
Yeah. Yeah, if necessary, so.
Okay, ordinarily, I guess that's not so. I was going to say ordinarily, we would have a discussion of the attorneys leading to the 15th, but under these circumstances, given that Mr. Cohen is a pro se litigant, that's inappropriate.
Well,
everything's but I think everything's got to be on the record. I don't think anything should be off the record.
I actually agree with Mr. Stone that we should have every conversation on the record here.
Yeah, I don't want there to be any confusion or misunderstanding. I think it's
well. Listen, I'm not saying we're gonna have that conference. I want your contact information, and it's possible that we'll need something.
Okay, that's okay.
But I'm hopeful that both briefs are gonna be so lucid and so informative that I'll have no questions, and I'll just be seeing you on the 15th.
Mr. Kickert, I'll forward my information to Ms. Dickert, and she can be the conduit for everyone's information.
No, you forward it to Mr. Stone and Mr. Kittredge directly.
Yeah. Okay.
Yeah, directly to me.
With a copy to Ms. Dickert.
Yes.
Yeah.
Yes, sir.
Okay. Same for you, Mr. Stone.
Of course. So that's all I have.
So, Mr. Chairman, I think there's, without further notice, this matter will be carried to the October 15th meeting.
Correct.
With the briefing schedule as outlined, and
the communication system as discussed.
yeah, and at this point, we still have not accepted jurisdiction in the matter.
Correct. That okay, Mr. Stone?
I'm ready to go. I'm going to go
Kittredge
hit the books tonight.
and Mr. Cohen.
Yes, sir.
And no issues with the timeline, Mr. Stone, as far as
You can
the application being accepted and.
right. You consider this the acknowledgement that we can delay it until the October meeting.
Yeah. Okay. Thank you.
Do we have to make a motion or that was done? Mr. Kittredge, do we have to make a motion?
You can make the motion based on what I just stated.
I make a motion that the discussion on a continuation and the correspondence to be forwarded accordingly. There a second?
And the hearing to be October 15th.
And the hearing to be October 15th.
I have one question. May I ask?
Hold a second. Go ahead.
I'll second.
No. Hold the second. Mr. Stone wants to say something.
Yeah, I have a question. One of the concerns of my client is that we want to shore up the building for safety and to make sure that there's no damage to the building. I'm not sure that the zoning board can give that approval, but my intention is to communicate with the building inspector to see if he'll allow us to cover up the building.
It's
fine with us, me.
Well, that's not,
it's not a zoning issue.
That's at the Board of Adjustment. I can't give you any guidance on that.
It's an inspector's issue.
Okay, good. Well, we'll take care of that with the inspector.
Okay, now you can second whoever seconded.
I'll second it, Dave Cortelli.
Is Christie back on or no? Mr. Alfuso?
Yes.
Mr. Wade? Mr. Wade, yes or no?
Christy's listening. She's
I'll
on
help.
the phone.
You're on mute, Mr. Wade. Mr. Wade, yes or no? Yes. Mr. Wade, yes or no?
You can mute him.
Mr. Mayor?
Mayor
Yes.
Rosenberg?
Mr.
Mayor,
Phillips?
sorry, Chair Rosenberg?
Oh,
Chair
well-
Rosenberg?
Yes.
Christy is on the phone. She's going to call the names and have me just write them.
Okay, I was doing, okay, go ahead.
Sorry.
Or I can hear their responses. I'm just gonna call the roll.
Go ahead.
Okay.
Call Teresa Rosenberg.
Teresa Rosenberg?
Yes or no? You're on mute.
I'm sorry. Yes.
Okay.
Ms. Brunel.
Ms. Burnell?
Yes.
Quarantine.
Mr. Clifford.
Mr. Fratelli?
I was like, no, but the way she made it seem.
Yeah.
He goes, he's in transitional twos. He literally.
Okay. What's his next, Christy?
Oh, okay. Mr. Affuso.
Mr.
Yes.
Fuso? Okay.
Ms. Phillips.
Yes.
Mr. Wade.
Yes.
And Mr. Mayor had recused himself in the beginning, so Chair Rosenberg.
Yes.
Okay.
All
Okay.
right.
October 15th with no further notice.
Did you hear
Correct.
that? She said October 15th with no further notice.
Thank you.
I'm making a motion to adjourn, and the next meeting is September 17th.
I'll second that.
All in favor?
Aye.
Aye.
Thank you much. Thank you, everybody.
Night, everybody.
Thank you.
Everybody,
Thank you.
everybody be safe and healthy.
Correct.
Bye-bye.
He's gone already. He's gone. He looks old. We're done.